We are going to analyze the evidence question number 3 that was on the July 2007 bar exam. In this evidence question, I assume first of all that you've read the question, but in any case, let me give you a quick summary of the facts. There was a car accident, and a person named Helper was walking nearby, heard a crash, and heard someone shout. That red sports car just ran the light and hit the truck. Now, the sports car was driven by a person named Dave, and the truck was driven by a person named Polly. So Polly sued Dave, claiming that Dave's brakes were defective and Dave knew it, and therefore Dave was negligent. That same day, Dave had taken his car to a repair shop, actually just a gas station, but while mechanic was inspecting Dave's sports car for some other reasons, the mechanic inspected the brakes. And while the mechanic was inspecting the brakes, the mechanic said to Helper, who worked there, said, quote, "Dave had better get these brakes fixed. They look bad to me." Now you've got Helper on the stand, and Polly wants Helper to testify that while I was out there in the shop where I work with mechanic, mechanic said to me what I just said to you. Brakes are bad. And the question is, are you going to let Helper testify to that? Answer: evidence is admissible if it is relevant, has a proper foundation, and is not excluded. Evidence is relevant, as you know, if it has any tendency to prove a fact of consequence. Foundation: each type of evidence that exists, there are about 9 of them, has its own foundation requirement. That is to say, if you want to get some testimony in, of course the testimony has to be relevant. That has to do with the content of the testimony. But in order to get the testimony in at all, there are some requirements you have to satisfy. In the case of testimony, the requirements are personal knowledge and competence of the witness. If you want to get some opinion in, there are some requirements for getting that in. Of course, the opinion needs to be relevant, but that has to do with the content. But to get that class of evidence in opinion, the opinion must be rationally based on personal observation and helpful to the trier of fact. Documents: if you want to get documents in, of course the content of the document needs to be relevant, but to get a document in, it needs to be authenticated, and so forth. So for every type of evidence, it has its own foundation requirements. So evidence is admissible if it is relevant, the foundation requirements are satisfied, and the evidence is not excluded. There's only 3 reasons to exclude evidence, and here they are. Hearsay: of course there are lots of exceptions. Public policy exclusions, things like settlement conferences and so forth. And illegally obtained evidence. Of course this comes up in criminal law areas, and we're not dealing with that right now. So the question then is should Helper be permitted to testify that while I was at the shop, mechanic said to me, Dave's brakes are bad? Well, let's take a look. To get that evidence in, then, is Helper's testimony relevant? Well, certainly. It has some tendency to show that the brakes were in fact bad. And you discussed that a little bit. Foundation: well, Helper's evidence is testimony. If it's testimony, the question is, does Helper have personal knowledge that this happened? Well, yeah, Helper was right there when it happened. And is helper a competent person? People are presumed to be competent. And helper has to be sworn in also for testimony. Finally, we're going to let this testimony in because it is relevant. We've satisfied the foundation. Now we're going to look for exclusions. Exclusion, hearsay, but of course you have the present sense. Go through the whole analysis, explain what hearsay is, and point out that here the present sense impression exception may apply. Give the elements of the present sense impression, and then work the facts against that element, those elements. You recall present sense impression requires that the person made the statement at or near the time of the event, made the statement while they were still perceiving the event, while it was going on in some jurisdictions. In the federal rules, if they made the statement while the event was going on or shortly thereafter, and the statement explains or describes the event. So you give those elements and work your facts against that. There's your exception to the hearsay rule. Also, this is opinion. The mechanic is saying, I think the brakes are bad. And so if the mechanic is saying, I think the brakes are bad, that's an opinion, and you need to decide whether or not you're going to let that opinion in. Well, if you're going to have opinion, the foundation for opinion is personal observation. I mean, the opinion must be rationally based on personal observation. You can certainly make a case that the mechanic's opinion was rationally based on personal observation. And so that would satisfy that. Now, Polly might claim that the mechanic's opinion really is expert testimony, and therefore shouldn't come in unless the person takes a stand and they get voir dired and all those things that you do with experts. But I'm sorry, that's what that'd be Dave's position. But Polly would argue that this is not really expert testimony, that every high school kid knows how to look at a set of brakes, especially a guy, knows how to look at a set of brakes and say these brakes look bad. And that doesn't require any expertise. So the answer is yes, this evidence is admissible. Second, yes, about is number 2. The mechanic instructed helper to write on the order, quote, inspected brakes, dash, repair, question mark, and helper wrote those words. But now helper's on the stand and doesn't remember what he wrote, or she wrote. Are you going to let helper testify? And so what you really do, it's not like having helper testify, I'm sorry. You want to get this record in, this car repair record. That's a business record. Sorry, I got off track there for a minute. So is this business record relevant? So you look here. The work order, is it relevant? Yes, it's relevant because it tends to show that the brakes needed repair. Exclusions, it's hearsay. Use the business records exception to the hearsay rule. Go right down the elements. You have to know the elements. There's no way out of that. Go right down the elements and show they were satisfied. And then the work order, the statement on the work order comes in. The mechanic then said to David, when David came to pick up his car, I think your brakes are defective. And David said back, yes, I've noticed that they've been acting funny or something like that. So now helper's on the stand. Are you going to let helper, by the way, can I go back for a second? This work order here, if these business records are going to come in, they need to be authenticated. And you've got helper on the stand, so you can use helper to authenticate the document saying, yes, that's a business record that we keep at the shop. And so not only do you need to qualify the business records to get past the hearsay rule, but you also need, since it's a document, you need to authenticate the document. You should have helper authenticate the document while you're doing that. Mechanic said to David, your brakes are defective. This is relevant to show that Dave knew his brakes were defective, but it is not relevant for its truth. Pardon me. It's relevant for its truth, but you're not going to be able to get admitted for its truth. And the reason is because Helper is standing there in the shop, and Helper heard the mechanic say to David, your brakes are defective, and now Helper is testifying that Helper heard that. Well, you can't just come to court and testify to everything you hear, okay, unless you got a hearsay exception. And there's no hearsay exception here. Helper just happened to hear it. So we had hearsay exceptions before. So the statement that mechanic made to David, saying your brakes are defective, is relevant to show that David knew, but not relevant to show the brakes are defective. Finally, Dave's response is, David responded by saying, I'm not surprised, they felt a little funny to me. That is obviously relevant because it acknowledges that the brakes were perhaps defective. It's hearsay. Well, in the federal rules, it's an admission, and it's not even hearsay under the federal rules. Under the California and common law rules, it is hearsay, but there's an admissions exception to the hearsay rule. Finally, they ask you about the shouting. Helper heard the shouting. The shouting is relevant because it says what happened. It's hearsay if it's offered for its truth. Use the excited utterance exception to the hearsay rule. Bring out the elements, list the elements, and work the elements. Don't just generalize about these. You will not get the points from generalizing about these. You get the points from listing the elements and working the elements. Present sense impression also list the elements and work the elements. Okay, that's how that problem should have been analyzed, and that's the end of this lecture.